Hello students, welcome to Legacy AIS Academy. Today we are going to discuss about National Psychotropics Drugs and Substances Act, and recently an amendment has been done in this particular act because of a drafting error that happened in the earlier amendment, and due to which there were a lot of problems the judiciary and the police were facing in charging people under this act. So this amendment was very much necessary. So we'll try to understand that what was the drafting error, what are the some important provisions of the NDPS Act, and how the recent amendment will affect the implementation of this particular act and law both in the police station as well as in the court of law. So first of all, you try to understand that why we are discussing this particular topic or why this particular issue is in news. So actually recently NDPS Narcotic Drugs and Psychotropic Substances Act Amendment Bill 2021 has been passed by Lok Sabha on the last Monday. And this amendment is not like a general or we can say very important amendment, but this is a very unusual kind of amendment that has been done by the parliament. It is just an amendment within a single sentence that alters the numbering of the different provisions that have been given in the NTPS Act. And however, there were a lot of criticism about this particular amendment by the opposition. So we'll also try to understand that what is the point on which opposition were criticizing this particular amendment. Now we try to look into what actually is the amendment. So it amends the Narcotic Drugs and Psychotropic Substances Act 1985 and seeks to rectify a drafting anomaly that was created in 2014 amendment for the parent legislation. The main problem is with regard to a particular section, that is section 2, and within this clause there is a section, within the section 2 we have a clause that is clause 8a, and it corresponds to clause 8b in section 27 since 2014. The main provision of section 27a in which the amendment has been done is actually it prescribes the punishment for different trafficking and harboring offences that is committed by the persons for with regard to the contravention of the NDPS Act. So actually this amendment tries to amend the section 27A of NDPS Act, and that the amendment focuses on changing the numbering of clause 8A to clause 8B. So actually to understand the issues we have to understand three main provisions of the NDPS Act. First is section 2 8A, second is section 9, and third is section 27. So within section 2nd and clause 8A, it actually in the amended provisions, it actually defines what is the essential drug. Now why it is important to define essential drug? Because once the essential act are defined, then this such kind of drugs and medicines can be easily available to the people who really needed such kind of drugs without worrying about being charged under the NDPS Act. It's both for the doctors, medical practitioners, as well as the pharmaceutical agencies, as well as the pharmacy, as well as the local people or citizens of India, we can say. Then the second important provisions is in the section 9, which actually make manufacturing, possessing, transportation, import, interstate or export interstate, sale, purchase and consumption and use of essential narcotic drugs. So once the essential drugs has been defined under section 2 clause 8a, under section 9 these particular acts like manufacture, possession or all these particular essential drugs become it becomes decriminalized, and people can, or we can say the concerned parties can practice in this particular act. Then the third point is regarding to section 27, where it actually provides punishment for financing directly or indirectly any of the activities that is defined as a criminal activities or illegal activities within subclause 1 to 5 of clause 8a of section 2, or it also criminalizes any person who harbors any other person who is engaged in any of the aforementioned activities. And if any person is caused or any individual or group of individuals are caught under the provisions of section 27, then as per the rules, as per the rule of law, when they are taken to the judiciary can impose a fine of 1 lakh, minimum fine of 1 lakh, which can be exceeded up to 2 lakh. Similarly, if judiciary deems it fit, it can also provide a minimum punishment of 10 years for the guilty party, and it can exceed up to 20 years. Similarly, in some matters where we can say the any individual has committed a very grave offences with regard to section 27, then judiciary has also been given the right to increase the limit of fine up to even 5 lakh rupees. So if briefly we can understand that as per section 27 as per section 27 of NDPS Act, if any person is engaged in any of these activities directly or indirectly, he can be fined to maximum of 5 lakh rupees and can be imprisoned for maximum 20 years in prison. Now, what was the actual error in drafting that happened in 2014 was that in that particular amendment, they actually renumbered the section 2nd of, we can say, NDPS Act. Then the second problem was that offences earlier, before 2014, all the offences that is defined as per NDPS Act was included in sub clause 2 and sub clause 8A. Those offences had been moved to section 2 clause 8B. However, in the amendment, section 2 8A defined essential narcotic drugs. So let us try to understand what is the issue. Earlier, all the offences were described in section 2 8A. Now the offences are described in section 2 8B. But when we are talking about the charging certain individuals, then they are charged because they are violating section 2 8A. But as per amended provision, there is no offences in section 2 8A. So that was the main problems. They changed the catalog of offences from section 2 8A to section 2 8B. However, in amendment, they still said that people will be charged if they are in contravention to section 8A or are caught under offences committed under section 2 8A. So this was the drafting. And due to this, what were the implication of this drafting anomaly? That as we discussed, that section 27A punished offences mentioned under section 2 8A subclause 1 to 5. However, it is now in section 2 8B. However, section 2 8A subclause 1 to 5, which was supposed to be the catalogue of offences, does not exist. I will discuss after 2014 amendment. So technically, that was the problem that the judiciary as well as police has to face. This error in text means since 2014, actually section 27A was inoperable. Again, to understand, section 27A punishes crime that is given or defined in section 2 8A. But as per the amendment in 2014, now there is no offences that is in section 2 8A. All offences are in section 2 8B. That means technically a person cannot be charged of committing a crime under section 2 8A. So, if we try to understand, interestingly, how was it noticed? So first of all, our first time it was noticed by a district judge in the West Agartala, that is Tripura district, Tripura state, and here actually taking advantage of this particular problems or taking advantage of this particular lacuna in the bill, the drafting error in the bill, a bail application was filed by an accused on the ground that section 27A penalized a blank list, and that is why he should not be charged under any offence. And the matter was then, as the matter was referred to the West Agartala District Court, the West Agartala District Court referred further this matter to the High Court to understand the legal implications these drafting errors. Then when the High Court matter was referred to High Court actually said that the District Court has to read the provisions the way it was intended and not the way it was drafted. That means basically, yeah, there is drafting error, but the government wanted to penalize people, the government wanted to criminalize certain offences, and there is just slight problems there. The offences are mentioned in section 2 8B. So on this ground, that there is no such we can say there is no such criminal activities that is mentioned in section 2 8A. The bail application cannot be granted. So that is why the district court then quashed the bail application, and the person was then sent to the judicial custody. The government has also said that drafting error cannot be a grounds to seek bail and must be overlooked. We have to understand the substantive provisions. We have to look at the intention of the government and not look at the actual the written statements of the provisions and the acts. Also, High Court has said that reading could not be applied retrospectively. That means after the amendment, if some person is caught, right now there has not been any amendment, but if any person is arrested now, then he should not be penalized as per the act that was in year 2014. So reading could not be applied retrospectively. What it actually means is that retrospective application, why it cannot be done? So Supreme High Court has said that it violates Article 20 clause 1 of the Constitution, where we have provisions that any person cannot be charged twice for the same crime, and any person cannot be tried for the crime that has not been crime as per the legal test when he or she was arrested. That means a law cannot penalize a person when it was actually not in force. That is what it means. 21 of the Constitution. Then what is Article 21A? If 20 clause 1, if you look at this clearly, it says that no person shall be convicted of any offence except for violation of the law in force at the time of the commission of the act charged as an offence. nor be subjected to a penalty that is greater than which might have been inflicted under the law enforced at the time of commission of the offence. Simply, we try to understand this point from a simple example. Suppose a person A has been charged for some crime X. Suppose he was charged for this particular crime, or he was arrested for this particular crime in year 2008. Now, this law X, which penalizes this crime, has been amended in year 2020. And earlier, for this particular crime, the imprisonment was 5 years. Now, as per amended provisions, this imprisonment has been increased to 10 years. So, since this person was arrested in year 2008, and at that time, as per the law in force, the maximum imprisonment was up to only 5 years. Now, still, if a person is being charged, the same person X A is being charged after 20 years, for him, he will not be penalized and will not be sent in jail for 10 years, because at the time of his arrest, the law said the maximum imprisonment for this particular offense is only 5 years. So that is why Article 21, and that is what Article 21 refers and provide protection against any draconian changes in law to the people who are arrested earlier. So that is why, as per Article 21, respectively, cannot be. Now the problem or the debate on the basis of which the opposition parties were, we can say, protesting against this particular amendment was that we have ordinance. The government has clearly stated this point, and the Mukul Rohtagi, who was the Solicitor General, he has also said the same point in judiciary, that the ordinance was brought to rectify the drafting error, and however the government has tried to make the application of this particular law retrospectively. That means the amendment, there was a drafting error in 2014, and now this error has been cleared in year 2021. So 7 years has passed. So all the people who has been arrested as per these provisions, on them, all the application, all these people who have been arrested in last 7 years, on them the amended and the correctified law will be applicable. That is what the government wanted to make sure. And the reason why they have said this, and the reason why government has validated its point, is because the government has said that there is no substantive amendment in the law. We just have a clarificatory amendment. Some drafting error was there. That is what we are going to change, and that is why it should be, or it can be applied retrospectively. Indeed, if any substantive changes were made in the law, then it could not have been applied retrospectively. So that is why the government's decision to make it application retrospectively is does not violate the rules and the laws of the constitution. However, the opposition parties have raised a voice, and they have said that can a substantive sentencing provision in criminal law be given retrospective effect by legislative declaration? Government has said that yes, we can apply this particular law retrospectively. But what about if suppose that in future they can bring some substantive changes in criminal law? Will that also be applied retrospectively? Because it can create actually a bad convention in the practice, where government start applying the law retrospectively, and that can go on and on for every kind of changes that government is trying to make in the law in the future. Second problem is that because of this decision of government, it raises more constitutional question, and some people have also said that government is doing a double mistake. Already they have did this mistake. They have done this mistake in year 2014 when there is this drafting error, and again by applying this law retrospectively, they are doing the second mistake of their judgment. So that is the whole debate is all about. So that is all about the end. And I hope you understand this particular topic and you understood the whole issue around that. We'll come again soon with another interesting topic that is in current affairs and that is going on news. Till then, take care. Thank you very much.